Thank you so much, Greg, for joining us to talk about your experience in your past as a medical debt collector. We really appreciate you taking the time to share your inside tips and tricks, but also to just help consumers know what they're dealing with on the other side. We are really excited to have you join and talk more about your experience, like I said. But before we do you want to just take a second to introduce yourself, tell us who you are, maybe tell us a little bit about your company, Debt Brief, and anything that you think people should know.
Sure. I'm Greg Anjewierden. I'm an attorney in Utah. I have a company, Debt Brief, that provides resources to people that have been sued by debt collectors. And mainly what I do with that is consultations with people. Because it's expensive to hire a lawyer, basically I teach people how to defend themselves in a debt collection lawsuit from start to finish.
Very cool. And what type of law do you practice outside of Debt Brief?
Insurance and medical malpractice defense in my law firm.
Very cool. So you've got a lot of experience with the law. How long have you been working as an attorney?
About 15 years.
Well, let's just jump right into some of the questions I have for you about your experience working in the debt collection space specifically. Can you tell us a little bit about what you did as a medical debt collector, and if you can share maybe like the medical debt collection companies that you worked with?
Yeah, so I didn't work for like junk debt buyers or third-party collectors like LVNB funding or Midland funding. Like I didn't do that. What I did was like first-party collections. So like I mentioned, I do a lot of like medical malpractice defense. So we've got a lot of doctors and clinics and nursing homes and dental offices that are clients, and they would obviously have bills that would go unpaid. Part of our services to them, we would do a lot of their collection efforts. So, we would sue on behalf of those companies and to get the medical bills paid. So I didn't work for like one company, but like through our firm, we would, whatever medical provider needed collection efforts done, we would do that for them.
Gotcha. So your law firm represented a variety of clients that were specifically healthcare providers or hospitals that were trying to collect on medical bills that were unpaid.
Yeah, exactly.
Gotcha. And can you tell us a little bit more about like how debt collection law firms are structured and like how they work with the clients? Like how do the clients find them, and how does that work?
I mean, for us, we were doing their other legal work, right? As you can imagine, like medical providers have a lot of legal issues to deal with. And so they would come to us and say, we've got these bills that are not being paid. Can you help us with that? And then we would help them with that as well. So ours was a little bit different than most collection law firms in that we were mainly doing this medical malpractice stuff, and then we would do some of the collection stuff for them. Most collection firms are going to be structured where, they've only got a handful of attorneys, maybe one or two attorneys, and a whole team of like paralegals and secretaries that are doing most of that work, with the attorneys only doing the work where they go to court. We were a little bit different in that way.
Because it sounds like the collection part was a little bit secondary, but you still did medical debt collection specifically.
Yep. Oh yeah, a lot of it.
So can you tell us what that was like making phone calls to consumers or people who owed medical debt, and what the conversation usually looked like or sounded like?
Yeah, so, for a lot of these, they would have like collection companies they would work with, right? And they'd send it to those collection companies, and the collection companies, they wouldn't sell the debt to the collection companies, but they'd hire them to be like, hey, get this. And the collection companies are making these phone calls and just like hounding people, like those calls that we all get, right? And then when that didn't work, they would send them to us. So, these were not easy debts to collect, right? It wasn't like, someone sat that bill on their counter and just didn't get around to paying it, and you had to make a phone call and remind them, kind of a deal, right? Like that wasn't where we were at in the process. So that had already been tried by somebody else. So, we kind of took the approach of, we're not going to mess around and waste time picking up the phone and calling you, right? Because people don't answer, or, they might try and avoid you or whatever. Our approach was, we're going straight to a lawsuit, and we're going to try and, freak them out, so to speak, and get them to call us, right? Because they're going to get sued, and your name is, my name's sitting there at the top of the summons and the complaint. And, what we were hoping would happen with all of these is that they would call me.
Gotcha. So it was almost like an intimidation tactic to get people to communicate with you.
Yeah, exactly.
So just to clarify, the hospitals or healthcare providers would hire a debt collection agency that would make the calls for them. And if they couldn't get through to the person that owed the bills, then it would come back to your firm and you guys would just immediately file the lawsuit in attempts to get the consumer to, I guess, engage in a conversation and try to settle it somehow, right?
Yep. Exactly. I mean, and sometimes they're not going to engage with us anyway. Like, it wasn't just to get them to engage with us. That was certainly what we were hoping would happen most of the time. But if they didn't, we were going through getting a default or summary judgment.
Gotcha. So how often would they respond to your lawsuit?
More often than not, someone would call. It was usually some kind of story about how they can't pay anything, which we usually weren't going to drop it for nothing unless there was some kind of proof that this person's definitely not going to be able to pay. We didn't just take people's word for it, so to speak, I guess,
Yeah, that makes sense. So what circumstances would the law firm drop the medical debt collection case? What did the consumer have to prove in order for your firm to drop the case and say, we won't worry about collecting on this one?
Yeah, well, the kind of debts that I was dealing with, since it was medical debt, I mean, usually if we were dropping it, it was probably this person is dead, right? Like they're deceased, and it was clear from research or whatever that the estate didn't have any money. When it comes to medical debts, especially, you encounter this, right? Like somebody's very sick and they're in a nursing home or they're in a hospital or whatever, and you're trying to collect these debts, and then they pass away, and it's like, well, how do you get the money now? Well, if they had money, if they had assets, maybe if they had a home or something, you can collect those, but we can't go after their daughter, for example. And a lot of times that would be the person that might call as the daughter. And I know, I'm sitting there knowing I can't get money from her, but, people were funny about their parents' money. A lot of times they were like, nope, this house was passed down to me. And, so if it was, well, this person has passed away and there was nothing and we can, verify that, then a lot of times we would drop it. But, a lot of times these people were, well, I'm living in mom's home now. And, we would say that home doesn't belong to you yet, kind of a deal, that kind of stuff.
What does that process look like if someone is sued for medical debt and then they pass away and their assets are passed on to family members? What do you have to do as a medical debt collector to, I guess, seize those properties and collect on that?
Yeah, I mean, technically those properties don't belong to the children when the parents die, right? And we're getting into wills and estates kind of stuff here, but that stuff passes to the estate, and then the estate has to go through probate, so to speak, and basically all the debts of the estate have to be paid before heirs or the children get that stuff. So a lot of times we're doing those kind of fights, and we're forcing people into probate court and things like that to make sure that we get paid before they get paid.
So if a person inherited their parents' house and there was medical debts that the parent owed before they passed, if the child wanted to sell the house, they would probably have to give a portion of it to the healthcare provider before they can sell the full amount, right?
Yeah, and a lot of times what we would do is, we would make settlements with them where they were like, well, we're working on selling the house, but we don't have the money right now. The only asset is the house. And so we'd make a deal with them. When the house sells, you'll pay this amount of money. The other thing that we would do is we'd put liens on these homes, right? So, and this can be the long game for a collector, is they'll put a lien on the home and then we just sit and wait. And, one day you get a call from a title company who says, hey, this house is being sold and you've got a lien on it. We just want to verify some details. And then we'd get a check in the mail when the house sold, because the proceeds from the sale are coming to us before they're going to the seller.
Gotcha. So that's typically what a lien looks like in a debt collection case.
Yeah. And we would wait years sometimes for those. We'd get the judgment, we'd do the lien, and honestly, as a collection attorney, you'd kind of forget about these. And then one day you get a call and they're like, oh, we got a check for $30,000 for you.
It almost sounds like passive income to me.
I mean, it doesn't feel very passive when you're on the collection side, right? It's passive, but you've got so much work to do.
Yeah.
And I think this is, a lot of people who are going through debt collection, they panic and they're just like, well, can they put a lien on my home, or can they just garnish my wages? And yes, they can. But there's a lot of work that goes into you. I can't just send your employer a letter and say, send me the garnished wages, right? I've got to go through this whole court process first, which takes a lot of time. It takes a lot of different filings, unless the person who is the defendant, the debtor, doesn't do anything, right? So it's like, oh, if I can just file the complaint, serve the summons, get the default judgment, I can do this really quick, and then it can be more passive. But if the person is filing an answer and I've got to go through this discovery and I've got to go to a trial, maybe file a motion for summary judgment, now it's a lot of work for a collector. On those ones, those are the ones where we're maybe giving better settlement deals because I'm taking into account how much time I'm going to have to spend on this case when somebody files an answer.
So it sounds like if someone has been sued for debt and they file an answer, then the law firm will probably take into account how long the legal battle may end up being, and they may be more likely to settle for less if an answer has been filed. Would you agree with that?
I would agree with the caveat that every case is a little bit different, right? So that's certainly no guarantee. But the way that I try and describe it to people and the way I teach it to people is if you're trying to get a settlement, you're trying to create leverage in your negotiations. And how are you going to get leverage? Well, one thing you can do is show the attorney on the other side that he or she is going to have to spend a lot of time on your case. If I don't file an answer and I just call them up, they may say, let's just wait a couple weeks and see if they fail to file an answer, and then I can just get a default judgment, right? But if you file that answer, they know, okay, we're now going to have to go through this whole court process. It's probably 6 to 8 months, if not more, for me to get to a trial. Best case scenario, I'm filing a motion for summary judgment, which is going to take me some time to do. And so now I'm thinking, well, can I just get rid of this fast, even if I take less money, right? Because attorneys get busy and overwhelmed, especially collection attorneys, because you've got to have so much work in order for your firm to be profitable. So yeah, it's not always true that you'll get a better deal if you file an answer, but I think a lot of times that's true because you're creating a little bit of leverage for yourself in those negotiations.
Perfect. I think that was a perfect answer and very well said. Thanks for explaining. My next question is, why did you decide to switch from, the collection side to consumer rights side?
I mean, I didn't like doing collections. You're taking money from people that don't have a lot of money to start with, right? Someone that's in a difficult situation and you're putting them in an even more difficult situation. Even though it's owed, I just didn't like doing that. I think the other thing is, from an attorney's point of view, when you're doing litigation, I do medical malpractice, right? And this is an area of law that's very complicated, and you can use a lot of creativity and strategy in those kinds of cases. There's no creativity or strategy in a collections case. It's turning through paperwork. From an attorney's point of view, I never found it very rewarding or fulfilling. You read these statistics about the number of debt collection cases there are. It's by far the most common type of legal case. And most of the defendants do not have attorneys. So if you're thinking like, well, most people that go to court have an attorney, actually that's not true. Most people that go to court do not have an attorney because most of the people that go to court are debt collection debtors, right? And so I'm thinking, how can I help these people? And it's not as simple as just do a debt collection defense law firm. People can't afford to do that. And there's a lot of courts in Utah, they have a program here where if you've got a hearing for a debt collection case, you'll have a volunteer attorney, and I volunteered at those, but that was like a temporary thing. Like we'd help them just for that hearing, and then they were on their own again, 5 minutes after the hearing. And so I just came up with this idea of, well, if I can teach people how to do it, that's going to be such a valuable service to them. And it just became this like really rewarding thing for me, is helping people navigate the process. Now, some people say, well, these people owe money, right? You should just pay your bills. I'm sure you guys get a lot of comments on your like YouTube videos and things, because I do too. Like people are just like, tell people to pay their bills, and I don't see it that way. I see it as we've got this court process here. Everybody deserves to have a fair shake in that court process. And I tell people that I meet with, there's nothing that I can teach you that is guaranteed to get you out of paying your debts. But I can teach you how the process works, how the game works, so that you can get the best result. And I think too, that when the debtor participates, it's good for the creditors as well. I think it's less work for them. If you reach a settlement with a creditor, they're obviously taking an amount of money that they think is fair. So I don't see it as I'm helping people getting out of paying their debts. I see it as I'm helping people navigate this process so that they get a fair result in the end.
How do debt collectors decide when to sue?
When I was working as a collector, when we got a case, I was of the approach of, I'm not wasting my time making phone calls or doing anything. We were just going to sue right away. Because like I said, I took the approach of, let's just get to it, right? Let's force them to make a decision whether they're not going to respond and we get a default judgment, or they are going to respond and then I can engage them in settlement discussions. With other collectors that I've seen, if it gets to the point where, okay, these phone calls, these letters obviously aren't working, now it's time to sue. What I do see though too is if they don't really have a good case, right? This especially happens with third-party debt collectors, junk debt buyers. They don't have the documentations they need. Sometimes they'll just keep pestering you and not file the lawsuit because they know that they're not going to be able to prove it in court. So they'll just bug you until you pay. Sometimes as a debtor, it can be tough dealing with all these phone calls and letters. And one thing you can do is send a debt verification letter or a stop collection letter. And that kind of forces them into this, unless we can prove this, we've got to stop. So that's one tool. I know SoloSuit has a debt verification letter that people can use and send out. And I think that can be a really good tool if you're like, I just want them to leave me alone. Like, let's either move on to the lawsuit or they need to drop it. Like, that's a really good tool to force it into that process.
Yeah, I think the debt verification letter, we call it debt validation letter, but I think the terms are interchangeable.
Yeah.
But yeah, a debt validation letter is definitely a good tool, especially if there's any part of the debt that, you as a debtor think is invalid or you've got any questions about it. It can be a good way to make the collectors prove all aspects of the debt.
Yeah, and let me add too. I think sometimes people freak out about getting sued. They obviously don't know the process, right? It isn't always necessarily a bad thing for a debtor because it forces the other side to prove. Now you send a debt validation letter and they have to send back validation, right? Like the law's not exactly totally clear on exactly what is required for validation, right? So sometimes you think, well, they should have provided more proof than what they've sent. Maybe, a lot of times for like a credit card, it'll just be one statement that'll say past due amount, but it won't have all the past charges. They don't have the credit card agreement. But once you get into court, you can now do discovery requests to request specific documents that you think they should have. If they don't have them, now you can say, look, you don't have the proof that you need to prove this. So going to court is not necessarily a bad thing for a debtor either.
So you're saying it's not bad for a debtor to have to go to court? In what ways?
Well, it's not always bad, right? Like, and I know I'm giving like my lawyer answer there, right? Like I'll never say like anything is always something or not. But like if you can you get the debt validation letter and you say they don't have what they need to prove that I owe this debt, I don't think. And they're saying, yes, we do, so pay up. Well, you can't go back to them and say, well, send me this. You can ask, but they don't have to do it, right? To send those specific documents. So you get into court and now you've got these formal court processes where you can send a discovery request and say, I want to see the original signed contract, or I want to see the statements that show each individual purchase that I made. Or if it's a medical debt, I want to see the original invoice that shows, itemized all of the medical care. And they have to provide that stuff to you. And if they don't, now you can say, look, now I've gone through this process and I can prove that you don't have the documents you need to make me pay this debt. So I think as a debtor, you want to approach a debt collection lawsuit as this is not just their opportunity to prove that I owe, but it's my opportunity to prove that I don't.
I love that. That actually, I think, kind of leads into my next question, which is more in the realm of debt settlement. If you do owe a debt, specifically a medical debt, are your chances of settling better than if you owe other types of debt, like a credit card or maybe a personal loan or something like that?
I would say yes, just because of the nature of who the creditors are, right? These are healthcare providers that are out in the community. And I'll be honest, I had clients who would say, they'd come to me with these debts and we'd make like an initial attempt to collect and they would say, you know what, just drop this one. We don't want to be seen as like the unscrupulous debt collector in the community, right? Because they see themselves as they're providing a valuable service. They're providing healthcare to people in the community. And so, and then I would add on top of that, a lot of them would have programs like charity programs where it's like, okay, somebody who doesn't have money, we're just going to pay for their bill out of our charity program. Right? So like definitely you've got an opportunity to settle medical debt, I think more than you would like a credit card or like a payday loan, something like that. Like those guys are in the business of getting you to pay them money. Medical providers are in the business of providing health care, right? So I just think they're more agreeable and amenable to reasonable settlements if you can prove that you can't pay. And I have a lot of clients and have dealt with a lot of medical providers that will also say, look, we will agree to lower this amount or drop it altogether, but we want you to provide verification that you don't have money, things like this. And then they would drop it. Now, as a debtor, you're kind of in the situation like, I don't really want to hand over my personal information, and you certainly have no obligation to do so. But, these medical providers, they've still got to, stay in business. So, they would a lot of times request verification, and if that was provided, they would drop it. So I would, to answer your question, I guess, yes, while I can't say that's always true, a lot of times you can get better deals settling with medical providers than you can with like a credit card.
Cool. Well, on that note, one thing we've learned about the debt collection industry recently that I didn't know about is that most creditors, when you're dealing with credit card debt, they'll have a minimum amount that they're willing to accept that they give to the law firms. So they'll say, hey, here's our cutoff of percentage. We cannot go lower than this, but this is our target amount that we're trying to collect, right? I'm curious if it's the same for medical debt collectors. Do they have cutoffs and percentages that they say we can't go lower than this amount, but if the debtor can pay this much, then we will accept within this range? What does that look like? How much do medical debt collectors typically settle for?
So that was never my experience, right? In my experience, it was always a case-by-case basis. And I think it's important to remember that ethically, the decision to settle lies with the client. So it was never my decision to settle a case or not. However, they're always going to listen to me and defer. If I tell them to do something, they're usually going to do it. And so, yeah, while there may be, creditors that are we'll never go below this amount, I actually don't think, as a creditor or a creditor's attorney, I think if you just set hard limits, and this is what we do on every case, I don't think you're doing a good job. Like I said, every case is going to be different. And it may be on case A, you've got a really solid case with all of your documents lined up. You've got witnesses that can come testify and lay a foundation for those documents at trial, and it's really solid. Case B, it may be, look, I'm missing stuff and I'm trying to, intimidate them into paying me, but I know if I go to trial, there's a reasonable chance I'm going to lose. And if I'm not adjusting the settlement amounts on those, then I don't think as a lawyer I'm doing a good job. That was how I felt on the creditor side of it. So we didn't usually take this approach of, we'll always go down to, we're always aiming for 50%, but we'll go no lower than 25%. That was never the approach that we took. Now, certainly there are creditors out there like that. But the other thing I would say is, they can say that everything's always negotiable, right? And I've seen a lot of cases where they'll say, we'll never go below, 50%. We just won't do it. Okay, well, what happens when you get a judgment and you start to try and garnish their wages, and the wages can't be garnished? Maybe you're in a state that doesn't garnish wages, or maybe this person doesn't have W-2 income, they're on disability or something, and they come to you and offer 25%. As a creditor, you have to think long and hard about taking that, even though you have this I'll never drop below 50% rule, because you can say, I'm going to stick to my rule no matter what, and you'll get $0. Or you can make an exception based on the facts of that case and get at least 25%. So certainly it happens that collectors set those rules. I don't think they're doing a good job personally.
So basically what you're saying is, even if a creditor has certain limits that they'll accept for a settlement and a threshold that they're trying, a target amount that they're trying to collect, it sounds like most debts are still negotiable, even if there are those limits set.
Yes, and it just may take time, right? Because they'll say, we won't go below 50% or whatever their number is. There's nothing you're going to say to change their mind at that point. Well, what can you do to change their mind? Defend the case, go all the way through. And if they start to panic and think, oh my gosh, we might lose this case, that number might go down. Or maybe they beat you, they get the judgment, and then they have a hard time collecting it. And you offer them a little bit of money that's below their limit. Maybe they'll take that because the circumstances have changed. And they're trying to maximize the amount of money that they collect based on the time that they spend. So while they may never drop below that limit early in the case, they might drop below it later.
Gotcha. How can debtors negotiate with collectors so that they can avoid going throughout the whole court process and avoid going to court altogether.
What you want to do is create as much leverage as possible in your negotiations. People always get sued and they're like, should I just call them and settle? Well, sure, you certainly can do that, but how can you create a little bit of leverage before you make that phone call? So I always tell people, file your answer first before you make the call, because then they don't think, well, this person will just get it, like we could just wait and get a default judgment, right? They know now, like we talked about earlier, they've got this whole court process staring them down, the lawyer does. So I always say, first thing you should do, file your answer. SoloSuit's obviously got a great tool for preparing an answer, and I would do that before I try and negotiate. The other thing is, you say, how do I settle this without going through this whole court process? I think you have to recognize that sometimes it's going to take going through the process to get the settlement you want. And I know SoloSuit has some good videos about different negotiation strategies that I've seen you guys put out, and those are all great. You just have to always be evaluating your case and saying, okay, if this is the maximum that I can pay and they won't take it, what do I do? Well, then you've got to keep defending and moving on. Recognizing that sometimes even getting a judgment against you might be the thing that you need to get this case settled, because they need to realize that they actually can't get the money from you. The other thing I would say is I really love the SoloSettle tool that you guys have, because it's sort of, a lot of people are afraid to call these lawyers. They're afraid they're going to say something that will mess it up. These lawyers are trained in the art of negotiation. You aren't. And it sort of takes that variable out of it, right? So you work through SoloSuit and they pass these offers back and forth, so you don't run the risk of saying something dumb or, being intimidated. I think the other thing too is, and this is especially true if you have a lot of debts, like multiple debts, and they're all going to be coming soon. If you make let's say you settle the first one and you've got 5 more that are going to be coming. You settle that first one, you write them a check, they now know where you bank, right? So they can levy your bank account on these next 4. So the other thing that I really love about using SoloSettle to do that is they don't get to know what your bank account information is. Like some of that personal information doesn't make it to that attorney. And I'll be honest, we would do this. We would save information on debtors so that if something came up with them later, we would know, okay, this is their information, this is where they work, this is their address, maybe this is where we bank. And if a case comes up with them later, now we have all that information. So I think it's a great tool to avoid a creditor's attorney from getting that from you.
Yeah, I may be a little biased, but I also think that it's a great tool. SoloSettle, it's a platform where people can go and send an offer to a debt collector without having to call them or talk to them on the phone. And they can use the platform to negotiate back and forth with the collectors and settle the debt all through a digital platform instead of having to, go to court or call or deal with collectors in person. It kind of reduces the tension between collectors and consumers. So yeah, thank you for sharing your thoughts on SoloSettle, because I agree. I think it's a great tool that can help people negotiate. Last question before we wrap up. What are 3 things that consumers can do to increase their chances of settling their debts?
Number 1, I've already said this, file an answer when you get sued. A second thing, what can you do? Don't be afraid of the court process. You may think, well, I don't know what I'm doing. I'm going to lose. You can learn. There are ways to learn. I teach people how to navigate the court process, right? So learn it so that you can recognize that, you might be able to call them early and they won't settle, but going through that process, cases have a way of settling as they get close to trial. Most cases that go through the whole process end up settling. And the last thing is, I would say just don't be afraid. Be brave and learn something new, right? A lot of people are when they meet with me, this is so interesting. This is something that I had no idea about before. And so you can learn how to navigate the court system and you can learn how to negotiate. So take the opportunity to develop a new skill for yourself. Even though you're going through this really difficult, stressful thing, it's an opportunity for you to grow and learn something new.
That's a really great way to look at it and kind of take a negative situation, but try to look at it from a positive lens and learn something new. I love that. Well, Greg, thank you so much for taking the time to share your experience working not only as a debt collector, but a debt collector lawyer, but also now I'm a consumer rights attorney. And if anyone is interested in learning more about the court process, like Greg was explaining, check out his website, debtbrief.com. There's a lot of tools and resources there that can help you navigate the court process and learn more about how to negotiate and settle your debts throughout the court process. Greg, any last words?
I would just say I love what SoloSuit's doing, and I would recommend that everybody check them out too, because I think those are really excellent tools to help yourself make it through this process. And we obviously talked a lot about settling today. Every tool on SoloSuit's website is going to help you settle the case, even the answer, right? Because I've talked about that so much today. So I would definitely recommend checking out SoloSuit as well.
Awesome. Well, thank you so much, Greg. It was a pleasure to talk to you and learn more about the debt collection industry and specifically the debt collection litigation and medical debt collection process. So thanks for sharing, and we just really appreciate you.
Great. Thanks.